A. Scott Bolden is a former prosecutor in New York. He's now a white-collar criminal defense attorney. Tanya Perry served as Deputy Attorney General for the state of New York, as well as Assistant United States Attorney for the Southern District of New York, and both join me now. Let's start with that argument that the Secretary of State of Colorado is making.
Well, I'm sorry, go right ahead.
Well, just because the state Supreme Court decision by Colorado very clearly was sort of aimed at Neil Gorsuch and aimed at the conservative justices on the Supreme Court because they knew it was going to get Supreme Court review, basically being like, look, this is state, like, what we're doing here is a matter of interpreting the U.S. Constitution, but also state law here. And really, like, you guys are real into the state courts and states figuring out eligibility. It seems like Jenna Griswold, the Secretary of State, is doing the same in that argument.
Well, yeah, and the Colorado Supreme Court wrote this with the conservative Supreme Court in mind. It relied on state rights, and it relied on strict constructionist and interpretation of the statute. That is, Section 3 is self-enforcing. As a former chair of the D.C. Democratic State Committee, I know this all too well because the states control federal and state elections, who gets on the ballot and who doesn't. And so how would you enforce someone keeping them off the ballot, as the Attorney General said, if they had been twice elected president? That would be a state right decision. The state would not put them on the ballot, and there's nothing really different here, other than they had a factual finding that he participated in the insurrection, if you will. So it's really not different, and there was a finding of facts. These 17 other states that are looking at this issue, some have made findings of fact, or 2 or 3 have. The others have gone through this kind of administrative process. But once you make findings of fact,
in a state court with, again, appellate review and due process and all that
with
stuff.
Witnesses.
Right.
And remember, Trump didn't put on much of a factual defense, especially in Colorado and I think in Maine or some of the other jurisdictions. They've just made these legal arguments that have left them wide open in regard to the Supreme Court and how they're going to interpret it. If the president isn't an officer or the chief executive officer of the United States, which is a government corporation,
right,
what is he then?
Right.
What is he, some agent acting on his own?
Right.
He's the commander of the military.
Right.
I mean, that dog won't hunt, as my grandfather used to say. It's just not going to. And the fact that they did not say whether he participated in the insurrectionists or not, as an insurrectionist or not, is a way to avoid that ultimate issue.
Right, but they're gonna have to find some. Look, they're gonna find some way to overrule his decisions. Well, the question is, what is it?
Well, I think what they're going to do, they could make that argument, or they could make another argument that says because we don't know what an officer is or insurrection isn't defined, that it's up to the federal legislature to define it. But there are lots of sections of the Constitution that are self-instructional, if you will, or define themselves. Article 3 courts interpret the Constitution all the time.
That's their job.
And that's the point that Jenna Griswold is making, right, where she says the constitutional amendment that bars a president from seeking a third term doesn't need congressional legislation to effectuate it. It just is part of, you can't make a state put that person on the ballot.
Exactly.
It's self-effectuated.
And it's a state right issue. It's up to the states to do that. One thing to watch, though, and this is completely off topic a little bit, is what does Justice Thomas do? Does he recuse himself or not? And what about Gorsuch? How much does he participate, given his prior ruling?